Welcome to Off the Record, a legal podcast.
Hello and welcome to Off the Record, a legal podcast with attorney Rhett Burney. I'm your host, Kevin Rosenquist, and today we're going to dive into the essentials you need to know about family law in South Carolina. Rhett, so good to see you again.
Hey, Kevin. How are you, sir?
I am doing great. Today we're going to talk about understanding custody matters in South Carolina. So what factors does the court consider when determining custody in a divorce case in South Carolina?
Yeah, there are a lot of factors. I would say that the main factor that the court really looks at is what is in the best interest of the child. The court will take into consideration, the parents' wishes, preferences of the child, those different parts of the relationship that the parents have played in the upbringing of the child, the mental and physical health of the child, the stability of each parent. There are lots of factors that the court considers, but the main thing that the judges always come back to is what is in the best interest of the child.
You mentioned the child's wishes. How much can the kid dictate how things go, where they live?
Yeah, I tell you, one of the questions we get all the time as lawyers is, at what age can a child make a decision as to where they want to go? And of course, when we get that question, we also get, the telltale sign of people going online and Googling at what age can a child decide. In South Carolina, where I am, there's no specific age. The court will look at a child's preferences and give weight to it depending upon their age and their maturity. Because, we have those cases where if you give a child chocolate cake all the time, they may choose that parent over the other one. So the court has to look at the whole situation to make sure that, what it's going to do is really in the best interest of the child. So there's no magic age. 18, of course, then you're an adult.
Right, yeah. In a custody arrangement, that's 50-50. Is that considered best interest of the child automatically or not always?
Well, not always. In South Carolina, where I am, the preference is not to do 50-50. Now, parents can agree to do 50-50, and in certain circumstances, 50-50 shared custody makes sense. But usually the default, based upon the case law that we have, the statutes that we have, the court will not go 50-50. But, as everything, it really depends upon your judge. It's not favored, but there are lots of people who agree to it. I think in practice, parents learn that if they get along well, it probably is in the best interest of the child. Of course, if they're living close together, that helps. If they live a long way away from each other, getting the child to the school, 50-50 is not going to work. So there are circumstances where if the parents, they're smart and really have their child's best interest at heart, they will arrange their living situations, schedules and such, so that the child does get to see the children. He does get to see the parent equally.
Yeah, but I can also see how it could be a drag for kids to constantly be bouncing back and forth between houses too.
Yeah, it can be. It can be. I'll tell you, I went through a divorce, and ex-wife and I, we sat down and we worked out a 50-50 custody schedule, where I would have the children on Monday and Wednesday. She would have on Tuesday and Thursday, and then every other weekend. That was a lot. It worked for us because we made it work. We understood the importance of being involved in our children's lives, but it doesn't work for everybody. You've got to be on the same page. You've got to be willing to make sacrifices, have to be willing to drive a lot and that sort of thing. But yeah, it can work, but it really depends upon the parents themselves.
Yeah, sure. So if both parents want primary custody and the court feels they're both perfectly capable, does it pretty much automatically mean 50-50 at that point?
No, not really. People get lost in terms a lot when they're doing their own research online. So when we say primary custody, to a lawyer, what that means is one parent makes the decisions for the child or children, such as those decisions concerning education, healthcare, religion, and extracurricular activities. So when we talk about primary custody, we're talking about who's making those decisions. We also get called in the terms of shared custody, sole custody, split custody. And really, when I'm talking to clients and potential clients, I tell them before they start focusing on the terms that we throw out there, focus on how much time you want to spend with your children. And then we can kind of define it from that point forward and put labels on it. At the end of the day, it really doesn't matter what you call it. It really matters on how you exercise it. But if you are a parent and you are labeled the primary custodian, generally you're the one who makes those day-to-day decision-making concerning those issues.
Okay. And what factors does the court look at when, to decide whether joint custody or sole custody should be awarded?
It gets complicated, of course, like everything else involving children. It looks at the parents' schedules. If you have a parent who works third shift, obviously they're not home when the children are at home. If you have a parent who is on call a lot of times, or an over-the-road truck driver, that will impact whether a parent gets full custody or primary custody or joint custody. We also look at the relationship between the parents with the child or children prior to the divorce or the custody case. It's not unusual to have parents come in and say, hey, they want to be primary custodian. Well, the history has shown that they really weren't that involved with the child. So courts look at that sort of thing. What type of interaction they have with their child? Are they available? Does their work schedule allow it? Are they spending time with the children doing their homework, getting them to school? We get even deeper. Does that parent have an addiction problem, a mental health problem? So, when we're dealing with custody with children, visiting with children, it's not a cookie cutter solution. Clients come in often and say, my sister's case, this happened, or my brother's his case, this happened. But really, it's never that easy. The court looks at all the different factors, all the different facts of a case in order to make a decision as to which parent's going to get full custody, sole custody, joint custody, primary custody. So many terms, but it's really going to depend upon each situation.
If after a divorce, if one of the parents decides they want to move farther away, out of town, something like that, how does that play into the decision as far as custody goes?
Yeah, well, one, it depends upon what the current situation is. If you have a 50-50 type shared custody situation and one parent wants to move, they may be moving, but they may be moving without the child. We also look at the reason why the parent wants to move or needs to move. If they just want to move closer to the beach because they like the beach, that's probably not going to be enough. If they get relocated because of their job or they get remarried, those may be some factors, or those are factors that the courts will consider in order to then figure out which parent's going to have custody, because the distance really dictates how much time a parent can spend with the child. It's a big difference between 15 minutes away and an hour away, because obviously you can't have a child on the road going to school at 3 o'clock in the morning if that one parent lives an hour or so away from where they originally lived. So we're going to look at the distance and why that parent's moving in order to see if it's going to change the custody or visitation arrangement.
Okay, that makes sense. What about when special needs children are involved? Are there special considerations there?
Yeah, those cases are really difficult. Again, it depends upon what the needs of that child happen to be. Some children have some really complex issues where that parent may have needed special training in order to be able to take care of whatever equipment that child may need in order to live. The child may have special behavioral issues that parent is trained to address. We have to look and see where the specialists are that need to be involved with the child's life. So, the court's going to take a look at those cases very, very carefully, and you're going to want to make sure that the parent that has the primary custody or primary visitation of the child is adept in taking care of those special needs.
Yeah, that's obviously adds a lot of complication to something that's already complicated.
Yeah. It doesn't make it any more simple, that's for sure.
Yeah. So what happens when maybe one parent has primary custody, but they're not following the custody agreement or the visitation schedule?
Yeah, so not unusual for people to break the court orders, right? Mm-hmm. And we look and see why they broke the court orders. If they did it voluntarily, they did it for nefarious purposes, they can be held in contempt of that court order. The judge can say that they have willfully violated that court order, and as a result, the court can fine them, can sanction them, can put them in jail, can make them have to do community service or pay attorney's fees. And oftentimes what the court will do, if a parent has withheld visitation, they will give makeup. The court will give makeup visitation for that child. And in some certain situations, depending upon how bad it is, how bad they have been violating the custody agreement or the court order, they can actually change custody or they can modify visitation.
Wow. If someone's the other parent not having the visitation rights they're supposed to have, what steps should they take?
Yeah, first you need to contact a lawyer if the the other side is not following the court order, you don't need to just let it go, because the longer you let it go, it waters down your case, because it wouldn't be unusual to have a court order, a custody order that you don't try to enforce as the visiting parent and then wait a while. Well, the court may look at the status quo depending upon how long you have gone and let the other parent run over you. So as soon as that violation occurs, you need to come sit down with a lawyer, get their advice. The lawyer's going to talk to you to find out, the gravity of the situation. Were they late 5 minutes? Were they just deny visitation completely? What was the reason for denying visitation? We'll look at all of that. We'll ask very detailed questions to then make a decision whether at that time is it in your best interest to go ahead and file a contempt action for violating the court order, or just keep a diary and let's kind of document to see how many violations there are, and then go to court and ask the judge to come in and punish the other parent.
Does that happen a lot?
Yeah, happens a lot. It's really amazing how often it happens. I don't understand why. You have people who at one point in time liked each other enough to have a child, but now hate each other. And I think what parents don't realize that in most situations, when you start using that child as the weapon, it doesn't necessarily hurt the other side. It really hurts the child, because children are smart. I don't care what age they are. They pick up on what's happening, and it can backfire sometimes for these parents who are withholding visitation. They think they may be hurting that other parent, but in reality, they may be pushing that child to the other parent. So as that child gets older, they may start putting pressure on that custodial parent to want to live with that visiting parent. So when we talked about ages earlier, as that child gets older, maybe that child starts voicing their desires more and more, to where the parent who originally was withholding visitation or was not following the court order has actually hurt themselves by pushing the child out of their house into the other parent's house.
That's a good point. And I agree with you too. Children are way more perceptive than we give them credit for. Maybe not always smart but for every time my 4-year-old puts a book out on his head and runs straight into the couch, he also picks up on things that I really wasn't expecting him to notice, and he references it later. So you're right. I mean, they are way more perceptive than we give them credit, I think.
Yeah, definitely. They definitely are.
So what are some of the circumstances that a custody agreement can be modified after the divorce is finalized?
Yeah. So, and that happens a lot as well, because as you know, with children, a 1-year-old is a lot different than a 4-year-old, which is a lot different than a 7-year-old. Their likes, their desires, they change as children get older. Their needs change as well. Here where I live in South Carolina, anything involving a child is never final. Child support's never final. A visitation order is never final. Custody order is never final. But in order to change those, we have to show a substantial change, material change in circumstances, in order to go back before the court to ask that the previous order that addressed custody and visitation be changed. And that could look like, for instance, where you may have a parent who's moving. That can be a substantial change. A parent could change their work schedule. One parent may not be taking the child to school on time, or that child may be failing school while in that parent's care. So, there's so many different things that can occur, but those are some of the things that judges look at, those things that they can really touch, taste, and feel. Behavior issues, school issues, how parents are treating the children. Obviously, if a parent gets arrested or addicted to drugs, those are pretty easy, but those are reasons for modifications as well. And it works on both ways. You can have a parent who only has visitation, but there could be a substantial change so that their visitation has to be limited or supervised or stopped altogether. Just like you can have a situation where that parent who has custody, they lose custody because of a change in the circumstances. Everything with the child is fluid. They're always, if you've got children, every season is a different sports season or a different type of extracurricular season, or every school season is different. So things with children are fluid. The courts realize that, and that's why there's always an open door to come back in to address the needs of a child.
Is it a difficult process to make changes to the agreement?
Depends on what those circumstances are, right? Obviously, you have a parent who's in jail. That's an easy case to modify the type of visitation. Just when we get into some of those nuanced situations where a child is no longer an A student, now they're a C student. That's not a bright line as a child going from A to an F in all their grades, or missing 20 days of school rather than 4 days of school. So we take it on a case-by-case basis. It's where we really have to look at it in detail as an attorney in order to determine whether or not we think that we can prove a case in front of a judge to show that there's been a substantial change.
Okay. And what can parents do to improve their chances of securing favorable custody arrangements?
Yeah, I think, of course, act and live like you're under a microscope. Nobody wants to live that way. They need to be careful what they put on social media, the way they communicate with the other parent. As lawyers, we have so many cases where parents are texting and emailing the other side and just saying terrible things to them, calling them names, threatening them, and those things rear their head. I think if you're a parent and you think you may ever go through any type of custody or visitation case, don't give ammunition to the other side. Don't say bad things to them. Also, keep a diary of events. If you're having to keep the child all the time, make sure you keep a diary, a calendar. If the other parent's late, substantially late, keep a calendar, because you're not going to remember months down the road all the specifics. We often have clients come in and give us this global explanation of what's been happening with their children and with the other side. They can't give us any details. We need details. Save those texts that are bad. Save those emails that are bad. Don't use illegal drugs. Make sure you get the children to school on time. Judges, they like those types of things that are really objective, like report cards, like absences and tardies and those types of things, because you can't really argue those away. They are what they are. So if you're the parent who has custody of the children, make sure you're doing everything you need to do. Make sure you're keeping the other side, the other parent, informed of school plays and extracurricular activities, Mother's, Father's Day at school, those types of things. Don't cut them out altogether. Just because you don't like the other parent does not mean that your children don't love the other parent. So keep them involved, because most of the complaints that we get are simply one side keeping the other side uninformed.
Yeah.
Communication is the key in everything. So keep that open communication. It's changed a lot since I went through a divorce. Now we have portal systems for the schools. So make sure that parent has the ability to log on. Make sure that you just put on a calendar, have a joint calendar with them saying, hey, little Johnny has a doctor's appointment on such and such a day. If you tell them what's happening, whether they show up, that's on them or not, but at least make sure you let them know what's happening. If the child's having behavioral issues, tell the other side, because they're still the parent.
Yeah. And communication, that is, I think, the key to a lot of the things that you and I talk about.
Absolutely. Absolutely.
All right. Well, thanks for tuning in to Off the Record, a legal podcast with attorney Rhett Burney. For more information or to connect with Rhett, you can visit rhettburney.com, and don't forget to like and subscribe to the channel. Rhett, so good to see you. Thanks for being here.
Same here, Kevin. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.